Why do I say that? I make a donation of 10 crores to a political party through an electoral bond. The political party opens a current account and 10 crores goes into that account. Now that political party can actually give that money to the mainstream media channel and say, you propagate my ideology, or give a present to somebody, or do what you want to do with it.
There are no spending requirements.
None, zero. That's the most serious issue. Because you can spend this money any way you like. You can build your offices. You can build your offices all over the country with that money. You can set up a whole internet network throughout the country with that money. You can use advertising campaign for whatever you like with that money. Show your face 20 times a day. And see the nexus. The corporate sector gives money to the political party. The political party and the corporate sector owns a media house. Just look at the nexus. The corporate donor owns the media house. The corporate donor gives it to the political party. The political party uses the media house. No questions asked.
Going on some
No.
instances.
I'm not talking of any instance. I'm talking about the scheme. Please do not interfere. I'm talking about the scheme. I'm not talking about any instance. That's the law. But this is, of course, hopefully it is.
Yeah, of course.
I thought we were sitting before 5 judges. I thought I realized by now it is.
Yeah, it is.
Yeah, thank you. Got to know about it from you.
The next point you want to make, Mr. Bhushan?
If your lordship just say that IFB Agro, so they disclosed under page volume 4, page 784. I told your lordship that Vedanta has been given various contracts, several.
You already told us that in spite of it being in losses, still it is paying such a amount.
Yeah, not just losses. I'm just saying that there are a number of mining contracts, etc., that Vedanta has been getting. It's also one of the largest donors of electoral bonds to political parties. So that much we know. Now, just see this IFB Agro case, page 784 of volume 4, document 77. These are just examples which will show that there is substantial indication that these bonds are being given by way of kickbacks to influence either government decisions or influence government policy. Now, just see 784 of volume 4. This is a disclosure made by this company called IFB Agro Industries Limited under the LODR requirements of SEBI. It says, we write in continuation of our earlier letters to the stock exchanges wherein we have intimated about excise-related issues being faced by or affecting the company. The board of directors in its meeting dated 31st March 2022 considered such issues and in the best interest of the company and all its stakeholders decided to approve contributions to political parties by way of subscription to electoral bonds in one or more tranches aggregating to not more than 40 crores in financial year 22-23. So this is a somewhat direct indication that they have given, that this one company has given, that it has subscribed and given electoral bonds because it was facing excise related issues. So to ward off excise related issues, they have paid these electoral.
Perhaps, Mr. Bhushan, we'll keep individual cases out of reckoning because, the reason is those companies are not before us.
No, I understand.
Also, any observation which we make in regard to those companies may implicate them in criminal wrongdoing.
I'm not saying that.
So we'll take it as a sort of an illustration by you to buttress your argument.
Of course.
The constitutional argument can't rest on that.
Yes, it is an illustration.
Also, as a matter of first principles, they are not before us.
I understand. Now, my lord, para 59 of my written submission, there is a quote from PUCL, that is that judgment by which this court struck down that Section 33B, which was brought in the Representation of People Act to obviate the disclosure. Now, this is actually a quotation from, given in that judgment, from the National Commission for Review of the Constitution, review of working of the Constitution. This says, high cost of elections and abuse of money power. One of the critical problems in the matter of electoral reforms is the hard reality that for contesting an election one needs large amounts of money. The limits of expenditure prescribed are meaningless and almost never adhered to. As a result, it becomes difficult for the good and honest to enter legislatures. It also creates a high degree of compulsion for corruption in the political arena. This has progressively polluted the entire system. Corruption, because it erodes performance, becomes one of the leading reasons for non-performance and compromise protection. Unaccounted funds from business groups who expect a high return on this investment, kickbacks or commissions or on contracts, etc. No matter how we look at it, citizens are directly affected because apart from compromised governance, the huge money spent on elections pushes up the cost of everything in the country. It also leads to unbridled corruption, and the consequences of widespread corruption are even more serious than many can imagine. Electoral compulsions for funds becomes the foundation for the superstructure of corruption. And then, my lord, there is a quote from Subramaniam Swamy that
we need not read. It's about corruption in politics and
yes,
elections.
and that corruption actually erodes everything in a democracy. And then in the supplemental judgment, page 34, Justice Ganguly's judgment, he clearly and directly says, today corruption in our country, para 81, today corruption in our country not only poses a grave danger to the concept of constitutional governance, it also threatens the very foundation of Indian democracy and the rule of law. The magnitude of corruption in our public life is incompatible with the concept of a secular socialist democratic republic. It cannot be disputed that where corruption begins, all rights end. Corruption devalues human rights, chokes development, and undermines justice, liberty, equality, fraternity, that are the core values of our preambular vision. Therefore, the duty of the court
Mr. Bhushan, actually, we can go to your last point, which is that this is a subversion of democracy.
Yes.
We will read your judgments. We have all the judgments now. How would you actually conceptualize it? How would you conceptualize it?
So, my lord, the argument is,
that's your third
is electoral bond, yes. If your lordship sees, the third argument starts at page 36. Now, if your lordship first looks at the quotation that I have given from the Law Commission's report at bottom of page 36. This is the Law Commission's report on electoral reforms. And this comes just before the electoral bonds were introduced, March 2015. So there's a quote from there. First is the undeniable fact that financial superiority translates into electoral advantage. And so richer candidates and parties have a greater chance of winning elections. This is best articulated by the Supreme Court in Kamarlal Gupta versus Amarnath Chawla, where there's a quote from that. Money is bound to play an important part in the successful prosecution of an election campaign. Money supplies assets for advertising and other forms of political solicitation that increases the candidate's exposure to the public. Not only can money buy advertising and canvassing facilities such as hoardings, posters, handbills, brochures, etc., and all the other paraphernalia of an election campaign, but it can also provide the means for quick and speedy communication and movement and sophisticated campaign techniques, and is also a substitute for energy in that paid workers can be employed where volunteers are found to be insufficient. The availability of large funds does ordinarily tend to increase the number of votes a candidate will receive. If therefore one party or individual has larger resources available to it than another individual.
Formulate it like this. Yes. Maybe your submission will be like this, that a party in power is in a much more vantage position to secure a greater amount of funding through the electoral bonds.
Yes.
Because of its ability to dole out a quid pro quo in the form of government contracts or government leases or licenses or concessions.
Or policy changes,
Or policy changes
or
which will
given,
benefit that particular industry.
or warding off excise issues, etc., etc. So there are all those.
All those
And
favors.
all those favors.
Yes.
And by therefore concentrating the allocation of electoral bonds to the party in power, this is a very important source of perpetrating power. And therefore it is contrary to democracy.
Yes. In fact,
I think that could be the formulation,
yes,
really.
today, money is universally recognized by the Law Commission, by various bodies, including judgments of this court, that money power or the very unequal use of money power erodes the concept of free and fair elections or a level playing field in elections, etc. And what this electoral bond is doing is that it is further making that playing field uneven by, as I showed, my lord, almost all the electoral bonds, 99.9% have gone, either more than 50% have gone only to the ruling party at the center. And the remaining, almost all the remaining have gone to ruling parties in the states. Only one party, I am told, that is CPM, which is before your lordship, has consciously refused to take electoral bonds. So even though they are the ruling party in one state, they have not received any electoral bonds. But otherwise, almost all the electoral bonds have gone only to ruling parties. And therefore, electoral bonds cannot even be taken by smaller parties which receive less than 1% votes. And they cannot be taken by individual candidates. Therefore, what this instrument is doing is, by privileging the ruling parties, because it's an easy way of getting your policies changed, your decisions changed, various other favors from the ruling parties. Obviously, favors can only be given by the ruling party, the party which is in control of the government. Therefore, it is further skewing the level playing field in elections. It was already skewed. But instead of setting that right, in fact, my lord, there should have been a limit on the expenditure of political parties. Instead of doing those things, or saying that political parties and candidates should only take money and spend money through banking channels, is doing exactly the opposite with electoral bonds. It's allowing, in fact, my lord, there are a large number of companies which do not have so much black money. They have only white money.
In the erstwhile regime, prior to the electoral bonds,
Yes.
a corporate entity could make contributions as well.
Yes, yes.
It was 7.5% of your profits.
Yes, but they had to disclose.
That's right. That's what I was coming to. The difference there was that you had a duty to disclose, so that by your disclosure, there can be a public scrutiny into whether this is really a quid pro quo for any benefits that you have received in terms of government contracts, licenses, policies, concessions.
So there are two separate arguments resting on this, my lord. One is that this is promoting corruption. This instrument of anonymized donations is promoting corruption. That's one separate argument, and corruption has been held to be part of, or a corruption-free society is part of Article 21 rights of the citizens. So this is one argument. The other argument is that it is actually eroding democracy itself, because it is skewing the level playing field between ruling parties and opposition parties on the one hand, and between parties and candidates on the other hand.
And another point, perhaps, which you may also want to explore is that this is not an anonymized donation in relation to the donee. It's an anonymized donation in relation to the rest of society.
Yes.
The donee may or may not, but could know who the source of the donation.
Normally they would know. Normally they would know, because
that's what I said.
Yeah.
So, according to you, therefore, when you say anonymized donation, it's not really anonymized in relation to the donee who receives the fund.
Absolutely, absolutely right. It's anonymized for the rest of society.
It's anonymized in terms of the disclosure of the name to the wider public.
Yeah. So it's anonymized at two ends. It's anonymized at the end of the company or the person who buys the bonds by the scheme itself, meaning that nobody else other than the person and the state bank can come to know who's buying the bonds. And law enforcement agencies, if they are investigating some act of corruption in relation to these bonds, etc. The second is that the political parties which receive.
That because of the exception carved out in the rules, the investigating agencies can verify that. But obviously, the general public is not aware of that.
Yes, yes. General public will not come to know. So therefore, my lord, it's at the one hand, on one hand, it is promoting corruption and thereby violating Article 21 rights. And on the other hand, it is skewing the electoral system in favor of the ruling parties and in favor of parties vis-a-vis candidates, further skewing.
But Mr. Bhushan, even if the earlier regime was there,
Yes.
the donations to the ruling party will be always more sizable in number compared to the non-ruling party.
True to some extent, yes. They would be more sizable in number, but I am saying that here,
So whether we have this system or the earlier system,
so here you are giving kickbacks. Earlier,
Earlier system also it could have been, but at least the donor and donee, they had to make the disclosures.
there you could be prosecuted. If you had given donations to a political party who in turn had given you some favors by way of mining contracts, etc., you could be prosecuted for corruption. But now, because nobody will come to know as to who has donated, whether you have received some quid pro quo, etc., therefore, it is promoting corruption, it is privileging. And if your lordship will see that now virtually all the donations or most of the donations are coming by way of electoral bonds. So therefore, and the bulk is going to the ruling party.
And in the case of a company,
Yeah.
now even the shareholders will not be told
Yes.
who you are contributing to.
Correct, correct.
The shareholders will only be given
Yeah.
the net result
Correct,
that we have contributed as a company 250 crores this year.
correct.
Shareholders now have no access to who you have contributed that amount to.
That's why in that Justice Chagla's judgment, that Tata judgment, they said that, yes, we are allowing you to change your memorandum because you are permitted, but you will have to advertise in the newspapers saying where and to whom you have donated. And they said that we are doing it because they have come to us with permission to amend the memorandum, but other companies may have already this provision in their memorandum or in their articles that they can donate to political parties. And therefore, at the end, they have cautioned that we are now advising Parliament to bring in a law which will make it mandatory for public disclosure. Of course, even earlier in the regime, citizens could find out who has donated to whom, because even when companies donated to particular parties, they were still obliged to maintain accounts and disclose their accounts in the company website. But ordinary citizen is not expected to be able to go through all the websites of all these 23 lakh companies to find out who has donated to whom, etc. Therefore, they said in that judgment that we are placing this condition upon you that you disclose it by way of advertisement to the public. And they said that because this requirement is not there for other companies who may already have political donations in their articles of association, therefore we are now advising Parliament to bring in a law to make this disclosure compulsory. Now, instead of doing that, we have gone exactly in the opposite direction. That we have now anonymized to the public even that possibility of coming to know from the returns of these companies who has donated and to whom, because that has been removed. So therefore, my lord, my submission is that this will This will destroy democracy. It's already, my lord, our democracy was almost a money game. It had become a money game. Mhm.
Got your third point also. You made your point. We then conclude now.
Just,
Can just wrap up now and.
I was, your lordship may just see this. I mean, I don't even have to
There's
read.
something crucial that we have missed out. You can show that. Just
Uh,
flag it for us and then we'll look at it definitely.
So I have, my lord, at page 37, 36. I have given the quotations from the Law Commission's report on
Fair enough. That
electoral.
we'll have a look at.
Now, these are quite important because they were suggesting exactly the opposite. They also suggested that this 7.5% is also too much. Large corporates can donate huge amounts of money. And my lord, Brazil Supreme Court, which we have also mentioned, Brazil Supreme Court has banned page para
Bhushan, that may
73.
have its own consequences in terms of source of collection of money.
Pardon, Lord?
That may have its own consequences because election funding is a major issue. It's not something very simple,
Yes, yes.
complicated issue.
So
Anyway, we have understood your.
So what is happening as a result of this is, as it is, my lord, the reason why elections became a money game, which is mentioned in all these reports, whether it's Law Commission or the Constitution Review Committee or various judgments of this court, one of the reasons is, my lord, that we have first passed the post in our system at two levels, when we vote for our candidate and then when we select the government. First past the post is that only that candidate who receives the highest number of votes, even if he gets only 30% vote, becomes the sole representative of that constituency. Second first past the post is only that party or coalition which has a majority gets the whole government and the rest of the opposition, even if they have 49% seats, gets nothing. The result of these two first past the post system is that when you vote for your candidate at the time of elections, you are not necessarily voting for the candidate or the party that you consider to be the best. If you feel that that best party has no chance of winning, you don't want to waste your vote. So then you say, all right, these are the only two parties which have some chance of winning or forming the government. I will choose the least bad, in my perception, among these two parties.
How is that relevant, Mr. Bhushan?
Pardon, Lord?
How is this argument relevant?
Because,
Are we going to change the constitution?
no, I'm not saying that. I'm saying that reason why elections have become a game of money is partly because of this first past the post system, because the perception as to which party has some chance of winning is formed on the basis of the visibility of the parties, and this is stated by the Election Commission very clearly, by the Law Commission very clearly in their report. That visibility is a function of money, because with money you can advertise, you can put up hoardings, billboards, you can have paid workers, you can do everything with money. Today even rallies are organized.
All right. I think we'll wrap up now, Mr. Bhushan. Yes.
What I was saying
Yes.
was that instead of curbing, instead
You
of
already said,
going,
instead of curbing it, promotes corruption. It interferes in free and
Thank
equal.
Mr. Bhushan, we'll hear you now in rejoinder if there is, once we hear the other side. There'll be a lot of.
all that I wish to say is
They'll cover
I
some ground which
I
we'll.
thank this court for
Thank you,
giving me
Mr.
this
Bhushan.
opportunity,
Thank you.
and I thank all my colleagues who have put together such an excellent
Thank you, Mr. Bhushan.
note. And
Yes, Mr. Sibal.
As my learned friend has with great perspicacity placed the points before your lordships and I will not repeat them. Whereas let's, in 4, 5, 7 minutes, let me broadly tell your lordships what my submissions are. Whereas your lordships must assume as a given that capital and influence go hand in hand. In fact, under the very concept of a market economy, capital symbolizes power. And it may be in any sector of the economy, as it is in politics. The more capital you have, the more power you have. That's number one. Point number two, the electoral process must be such that it must provide a level playing field to all participants. Fair and free elections, or free and fair elections, is the basic structure of the Constitution. Concept number two.
Just a second. Yes.
Concept number three, the moment you allow the corporate sector to donate, whether with transparency or without transparency, I'll come to that a little later, it is inconsistent with the concept of a corporate sector which is in the business of doing business. You have a memorandum of association which tells you what the objects of the corporation are. The shareholders put in their money to ensure that the corporation functions within the framework of the memorandum of association. Now you give the power through an amendment of this nature to allow shareholders' money to be used inconsistent with the memorandum of the association. It's a very serious issue. And without consultation and without the consent of the shareholder. Under which law, well, then I ask myself this question, can this ever be allowed? I buy shares in a company. It may be listed, it may not be listed.
But just one caveat, Mr. Sibal, which is that we are not here on the challenge to the legality of a law providing for corporate donations per se. That wider issue is not before
No,
us.
I agree. But
For the reason that's what Justice Chagla flagged, Chief Justice Chagla flagged even in 1958. He said there should be no corporate donation, but we are not really dealing with that. So
I'm not on that.
Really into that area at all, because 293 anyway allowed.
Well, I'm not on that. So, I'm on a wider
on what you said in the latter part of your formulation, without the consultation and the approval of the shareholders.
That's the point. Yes. That's the point. That's why I said.
Otherwise, the broader philosophical perspective that allowing corporate donations is really permitting some form of quid pro quo.
No, Malad, I'm not on that because my learned friend has argued that
broad area here, because in that sense, the moment we accepted 293, our society legitimized corporate quid pro quo.
Malad,
but there is an element of quid pro quo the moment you have corporate
Exactly, Malad. There's no doubt
therefore, about it. That's why a large public limited company who makes a donation doesn't give it for charity.
Exactly.
Or for, for
that's why I said capital and influence are Siamese twins, Malad.
So we shouldn't really in that
I'm not going there, Malad. I'm not. That's why I said that what you're doing in this process is that you are allowing through the electoral bond process to not inform the shareholder as to how his money is going to be spent. Right? And that's a very serious issue because he is invested in the company, not for the purposes of donating to X and Y. That's the third concept. The fourth is even more important. This is nothing to do with electoral bonds, if you ask me. It is donation to a political party to use the funds as they like. The nomenclature suggests electoral bonds means this is for the purposes of the election. There is nothing in the scheme. There is nothing in the scheme which connects the donation made to the participation in the electoral process. Nothing. It is a means for political parties to be enriched. Why do I say that? I make a donation of 10 crores to a political party through an electoral bond. The political party opens a current account and 10 crores goes into that account. Now that political party can actually give that money to the mainstream media channel and say, you propagate my ideology. Or give a present to somebody. Or do what you want to do with it.
There are no spending requirements.
None, zero. That's the most serious issue. Because you can spend this money any way you like. You can build your offices. You can build your offices all over the country with that money. You can set up a whole internet network throughout the country with that money. You can use advertising campaign for whatever you like with that money. Show your face 20 times a day. And see the nexus. The corporate sector gives money to the political party. The political party and the corporate sector owns a media house. Just look at the nexus. The corporate donor owns the media house. The corporate donor gives it to the political party. The political party uses the media house. No questions asked.
Constitutional argument. Going Ballard on some
No.
personal instances. Ballard.
I'm not talking of any instance. I'm talking about the
what you're
scheme.
talking.
Please do not interfere. I'm talking about the scheme. I'm not talking about any instance. That's the law.
Yeah, but grievance.
But this is, of course, hopefully it is.
Yeah, of course.
I thought we were sitting before 5 judges. I thought I realized by now it is.
Yeah, it is.
Yeah, thank you. Got to know about it from you.
The Article 14 argument.
Yes. Yes, Millard. The scheme is wholly arbitrary. It has to be struck down on its terms. It has nothing to do only with elections and how you spend your money in the electoral process. Now, let's kindly have a look at volume 4 and PDF 142. These are FAQs, Millard, that were asked where the scheme was from the SBI.
142.
140. Yeah, first I'll show you, Millard. 130. 138. Which is a given, Millard. Actually, I need not even mention this. At 138, the question is, what is the minimum and maximum limit for donation? The minimum amount for donation is 1,000. There is no maximum amount.
138, Mr. Sibal.
Question, Millard, at 31.
31.
Yeah. Just note it, Millard. We Lordship know, you know about it already.
That's okay.
Now come to 142. 142, question 6. Can a political party use this current account for other operations also? Answer is yes. Next question is 9. Can political party close this current account after the election? The account can be continued for normal banking operations. However, if required, the account can be closed at any time by the political party.
What are you hinting at, Mr.?
I'm sorry?
What are you hinting at?
Mullah,
Can
you
misuse?
close the account, that's the end of the matter, Mullah.
You get the money, close the account, but
That's it, and then you spend it the way you want. Well, this is not a scheme for well, I can understand. Well, quite frankly, I can understand the corporate sector being told that we impose a cess like education cess. You impose a cess on the corporate functioning of companies. With that cess, you have capital, and capital you distribute in accordance with the representation in the Lok Sabha. So everybody has the same amount, and the same money can be used for that. What you're doing now is entirely different. You are saying you give me as much money as you want to give me. That Aziz argued, Mullah, that
Your submission is this is not money for electoral participation, but money for
enriching the
political
party.
party,
Yes.
individual party.
It's just enriching the party.
There are no spending requirements. There's no
what's
auditing
no-
requirement as to how
no
the money is
accountability.
utilized, nothing.
No accountability. Absolutely no accountability.
What's the next point?
The last point, but the
Yes.
fifth point, is that in fact it protects the nature of the scheme protects those who have committed a crime. I'll give you an example. Under the Prevention of Corruption Act, Section 7 of the Prevention of Corruption Act, you give money to a public servant, members of parliament are public servants. Many members of the political party who are in the fray are public servants. Now, as your lordship knows, under Section 7, you can also prosecute a person in anticipation of a favor, not just having granted a favor. So you give a donation, no questions asked, you get a favor, you cannot correlate one with the other, and I can't prosecute you. This is a scheme to protect criminals from being prosecuted. Just read Section 7 with me.
Of the PCI.
Prevention of Corruption Act. This is also true under the PMLA. Because a predicate offense has been committed, it results in proceeds of crime. You'll never get to know. Rather than furthering the rule of law, it stymies it. That's the other Article 14 argument. You'll never know who bribed whom, how much was the bribe for, what quid pro was there. You'll never get to know. That there is quid pro quo, Mullahs, is in my first submission. That capital and influence go together. Mullahs, nobody can doubt that proposition, Mullahs. So in effect, through this scheme, you are trying to protect those people. Where the source of the money is, my learned friend has argued, I don't want to repeat anything that he has said. And well, let's see what is the scheme. If it's less than 2,000 rupees, it's cash. If it's more than 20,000 rupees, the name of the donor has to be given. And if it is electoral bonds, nothing. That's the 3 layers of the scheme. So while the donor's name will be given if it's more than 20,000 rupees, right? And so ordinary, ultimately, let's put it this way. This constitution is for the citizens of this country to participate in the election. The corporate sector is not a voter. The citizen is the voter. The citizen is entitled to contribute. If he gives more than 20,000 rupees, his name will be there. But the corporate sector, who is not a citizen, can donate 10 crores, 100 crores. His name will not be there. What's the rationale for that? I, as a citizen's name, it will have to be disclosed. So, is the corporate sector being granted a privilege over a citizen of this country? That privilege of anonymity? How is he more privileged than a citizen who is at the heart of the Constitution of India? How is he being given a preferential treatment? Why? Because you want to enrich yourself through this scheme. And enrich yourself because you're in power. Whereas the opposition may be in power in a state. They will also enrich themselves. This is not political. Because all business will actually be attracted towards this scheme because this is one way of getting access. I just pardon me, Maharaj, for saying so from personal experience. If people donate, Maharaj, we know who is donated. He will give me a call and say, sir, I want to come over. I will hear him. But if I don't know his name who is donated, Maharaj, I won't listen. How many calls will I answer? So you get access, straight away you get access. And all this anonymity that we're talking about is really not anonymous. Because the person who donates will go and tell him orally that I gave you such and such money. This is the amount I gave you, 100 crores. Only he will know that he gave.
The anonymity would exist only if it was truly fungible.
That's right.
In which case, if it's truly fungible, like a demat account, in which case, you give it to, say, the election.
Then it's anonymity.
And then it is, then it becomes anonymous.
That's right. Now it is not. In fact, it is not anonymous if you ask me. That's my summation. Because I have given 100 crores, I know that I bought a bond. My learned friend, Mr. Prashant Bhushan said, no, he give it to a third person, doesn't matter. But who is interested in that bond? The person who I bought the bond. So I will go and tell whoever I want to tell that I gave you. So he doesn't have to go to the State Bank of India. Let's talk practical politics. He doesn't have to go to the State Bank of India to find out. Nor does the State Bank of India have to disclose it. The person who gave it will disclose it. Because he knows why he gave it. So what is anonymous about this? This is protecting the rich.
There is another thing.
Yeah.
The issue which we were just discussing on, which perhaps the learned attorney may give us an answer, but since Mr. Sibal is on his leg, we will just put it to him, Mr. Attorney, and Mr. Solicitor, you can also, in your turn, you can answer. Suppose A purchases the bond.
Yes.
A purchases bonds worth X amount, 100 crores.
Yes.
A is only the person who's been put up to purchase the bond because
That's
that
awesome.
A has a KYC, etc.
Yes, yes, yes,
A has to only physically hand over the bond to B,
yes,
right? Who's in, or B gives it to C, who will in turn give it to a political party.
correct.
Now, B, there is no control over the transaction between A and B.
Yes,
So B can trade on that bond for cash or for
Yeah.
whatever other consideration.
yes, yes,
B acquires that bond.
yes,
B hands it over to a political party.
yes,
Or B gives it to C and C hands it over to a political party.
yes,
The person who has satisfied the requirement of the transaction being through the normal banking channels is A, the purchaser, the ostensible purchaser of the bond.
correct.
But this does not obviate the fact that the people who are really
Behind it.
behind it, that they have used authorized banking channels.
Yes.
All that they have to do is that the
Get somebody's
it
KYC.
says trading is prohibited,
Yeah.
but there's no way you can prohibit trading in the
Absolutely.
bond.
Absolutely.
B doesn't have to buy the bond from
No, he
A
doesn't.
through official banking
no,
channels
no.
because there is no record of any transactions in the bond. It
Yeah.
just goes from hand to hand.
That's right.
Because of the curtain, then you cannot be any questions with regard to quid pro quo.
That's right. And then, ultimately, the person who is actually invested in it is the person who will tell the political party. Who's the holder ultimately?
No. In this case, probably they'll know who's the
Could be
purchaser.
B or C.
They'll know the purchaser, but the actual purchaser is A. B.
Exactly.
Whereas in the KYC, etc., A is the one who's.
That's right. Absolutely right. So, this is, it perpetuates.
Also, B may be an aggregator of the bonds.
That also.
By having 10 different people subscribe to 100 different people subscribe to a bonds worth 1 crore each.
That's right. Well, there the human, at least the Indian human mind is ingenious in these matters. We control the economy of the world in many ways. And the RBI raised these concerns repeatedly. This is, we must show that. We now look at question C, frequently asked questions FAQ, page 138. Question number 36.
128.
138, question 36. My lord has that? Who is the bona fide owner of the electoral bond? Okay. PDF 138. Who is the electoral owner of that? Who is the bona fide owner of that bond? Electoral bonds are bearer banking instruments. It's exactly what my lord the Chief Justice said. And the holder of electoral bonds is the bona fide owner of the same. Nothing can be more anonymous than this. All that you need is the KYC, that's it. And then see 17 at page 31. Page 131, PDF 131, question 17. Can electoral bonds be purchased multiple times by the same applicant? Yes. Yes, every application will be treated as fresh request for electoral bonds purchased, and every time fresh KYC documents will be given. So you'll have bond brokers, you'll have in-betweens, you'll have all kinds of people participating in this. So it's not just a question of transparency, Malak. It's much wider than that. Last of all, Manoj, if I do not know these facts, if I don't get to know the name of the donor, I don't get to know the transaction, I don't get to know the possible direct or indirect quid pro quo, I can't participate in democracy. It is also a matter of participation in democracy. I will then be sued for defamation that you made this allegation without the facts. But how will you get to know? How will I get to know the facts if you hide the facts through an electoral scheme like this? I can't raise questions in Parliament. I can't raise questions outside Parliament. Because the scheme, Malaj, has no definite objective. If it were a definite objective of funding through the corporate sector, the process of election without funding a political party, I can understand. You can have electoral bonds to fund the election process. But what you're doing here is you're funding a party. It's different. The object is different. So you call it electoral bonds, but these are not electoral bonds. And the limit of expenditure has nothing to do with it. Well, it's 123(6) of the Constitution, of the Representation of People's Act, talks of expenses. Corruption, an act of corruption beyond 95 lakhs now. So the larger issue that your lordships will have to consider that this is no part of participatory democracy at all. Every scheme must have a legitimate object. What's the legitimate object here? Which is constitutional. The scheme must be such, it must be proportionate to the object sought to be achieved. And the underlying principle under the Constitution is free and fair election, which is a basic feature of the Constitution. How are you serving these three purposes, Madhus? You are serving none of these three. No legitimate object because it is not limited to the elections. No proportionality because it's unlimited. And no free and fair elections because my learned friend has shown to your lordships how heavily it is loaded towards the party in power. So you are creating a non-level playing field through the electoral bonds. And that's violative of 324. Now, Malas, historically, as your lordship knows, Malas, in 1969, through legislation, we had Malas prohibited corporate donations altogether. And then 1985, Malas, through an amendment, we said, okay, the corporate sector can donate, but only to the extent of 5% of the average earnings in the last 3 years, 3 financial years.
5% or 7.5%?
I'm sorry? Initial 5%. Whereas 85 was 5%. Then through an amendment, it was 2013 Act, it was changed to 7.5.
2013?
The Companies Act. Well, actually, I've put it all in the written submissions, but because my learned colleagues are waiting for me to end, so I'm not wanting to take their time, Wallace. Your lordships have said that do it be as short as possible. But whatever I have said to your lordships, my lords, are the propositions that emerge from the scheme itself.
Mr. Sibal, submissions are in which volume?
Volume 1.
Again, volume 1, right?
Yes,
Yes,
volume 1. All the submissions.
All the
are in
submissions
volume
are.
1.
Yes, we got.
Then it's page 48.
48.
PDF 48. And if you I'll take few minutes, Malad, then I'll be done, because my learned friends, I want to give them time to. The first, Malad, few pages are just the scheme itself, the electoral bond scheme itself, goes up to PDF page 63. My lords have that. It's just the elements of the electoral bond scheme which have already been explained to your lordships. So I will not trouble your lordships with that. That's been explained. But if you come to 63, then I deal with the issue of free and fair elections under the Constitution. And I say it's the basic feature of the Constitution. And it's now recognized that para 15, as I say, as will be developed below, any nature of funding that is opaque and that seeks to hide the source of funding is contrary to the spirit of free and fair elections, which is part of the basic structure. That's the transparency argument, plus the free and fair in the context of which, in the context of my submissions before your lordships now. Then election is a vehicle of representative democracy. I've given judgments, page 66, and then para 17 at 66. Is the constitutional mandate of free and fair elections under the principle of universal adult franchise is a central pillar of our democratic culture. Under our political system, elected representatives do not have any political legitimacy independent of the will of the people and must discharge their duties in public trust. But it must never be forgotten that this constitution is citizen-centric. It is for the citizens to decide to donate. If you want corporate funding, then that corporate funding must be for the electoral process. It must not be for political parties. Otherwise, it will not be free and fair election. Then, therefore, you must interpret superintendent's direction and control of the conduct of elections in that context. That's set out at page 67, end of paragraph 19. Then I differentiate between freedom and fairness, which is para 20. I won't trouble your lordships with the language. And para 24, I say economic power at page 68. Economic power presents a grave risk to any level playing field between individual citizens and groups, and can give some voices a disproportionate say in deciding the agenda of the political parties, and hence the laws and policies that will govern the entire country. In pluralistic democracies like India, practices must emerge that preserve the equal voice of all citizens and that ensure that the special needs of all groups are heard. But if the voice of the corporate sector drowns the voices of citizens, that's a very dangerous trend in democracy. Then, Justice Bhagwati's judgment in Kamalnath Gupta's case, let's leave that out. I think that's one extreme position, which I don't want to argue. And then, then this is important. Kindly see, para 36 at page 72. Reiterating my learned friend's submission that it's the voters' right to know. That's fine. And this whole concept of black money, I don't understand. The cash that is given below 2,000 can be black money. The 20,000 rupees has to be disclosed. That also can be black money. Because you can say cash in hand, 20,000 rupees. And the electoral bond can also be black money. And over and above that, there is black money. Because there is cash that doesn't go into electoral bonds. So what is this black money issue about? The kind of extravaganzas that we see, Malas, is what? Is it white money? So this has nothing to do with black money. This is the case of the government. That black money was used earlier, no doubt. Black money is used today, no doubt. There is more cash in the market than it was in 2014 or 2019. That's government's own statistics. So black money is a bogey. And all three elements can be part of black money. That can't be an argument. So dealt with. And then, so the three issues, Malas, I have raised at page PDF 75, whether corporate donations should be allowed at all, but that's not a question that your lordships has to answer. If yes, what kinds of companies should be allowed to make such donations? If corporate donations are allowed, what cap of net profits should be set? And who is the appropriate body within the corporation to authorize such donations? That's if you agree to all what the other side says. If you agree to what the government says, Malas, then these questions will arise. But that's subject to my submissions that I've made to your laws. The shareholder argument, Malas, I placed there, paragraph 43, the objects of the company and all that, which I've already commented upon. Then I've given the history. Then 2013, my lord asked the question, the cap of 7.5, that's at paragraph 47. And actually, Malas, there's a wonderful report of Justice Shah, I think at the Law Commission, which actually sets out the practices in all the countries, UK, US, Japan, Philippines, Australia, and Germany. And in all those countries, there is no question of any opacity. Most countries do not allow corporate donations at all. But where they do allow, there is no opacity. And this is all at PDF page. Your lordships may only note it, 296 in volume 4. That my lord selected. Prashant Bhushan has covered. That's really it, Malas. I want to take as little time as possible.
Thank you, Mr. Sibal. Thank you.
Deeply.
Yes, Mr. Pash. Yes, Mr. Farah, sir.
I appear, my lords, for writ petition 59, because we are the only political party before your lordships. And my lords, despite being a ruling party, my lords, we have taken a principled stance not to accept,
May I be excused for that?
Yes, Mr. Sibal.
not to, my lords, accept any electoral bonds, and we have not taken a single rupee of electoral bonds in the last 5.5 years. At, if I may say so, my lords, at much cost to us. My lords, there are 3 submissions, my lords, I'll try to make very quickly. My lords, first,
That report of the ADR, it says that your party has got some electoral bonds also.
no, my lords, that's because they gave us this thing. We have just given the detail because they asked when your lordship's order, when the order was passed that every party has to disclose details. So we would have just responded saying that we have not taken any electoral bonds. There's no question of taking any. This is a principal stance. We have not taken any. Plus the first submission I intend to make, plus 3 submissions. Plus the first submission is that the architecture and effect of the electoral bond scheme is not to reduce black money, but to reroute non-anonymous banking channel funding to anonymous electoral bond.
Please repeat.
Plus the architecture and effect of the electoral bond scheme is not to reduce black money funding, but to reroute the non-anonymous banking channel. Well, that is the conventional banking channel available.
Not to, architecture and effect is not to?
not to reduce black money funding of political parties, but to reroute the non-anonymous banking channel funding,
But to reroute,
the non-anonymous banking channel funding to anonymous electoral bonds.
To reroute,
Non-anonymous banking channel funding to anonymous electoral bonds. Well, that's the first submission. The second is that the legally ordained informational black hole, which this creates, the electoral bonds scheme creates. It's a legally directed information black hole, goes against the concept of informed electorate under 19(1)(a), read with my lords, Article 326 of the Constitution, both. So it goes against the principle which is constitutionally mandated of an informed electorate under Article 19(1)(a), read with Article 326. And the third submission for your lordship's consideration is that it violates the right to conscience under Article 25 of individual shareholders, because they don't know where their money is, what their money is being used for. I'll try to make that.
Mr. Sibal also argued.
Mr. Sibal argued, but he didn't pitch it on right to conscience under 25. I'm specifically saying it violates right to conscience under Article 25.
actually the 19(1)(g), right, you can say.
But also, I'll try to make it good, because I know it's not the usual argument to be made, but I'll try and make it good. Because on the first, before I begin with those submissions, just one aspect is this matter is essentially about two things, democracy and disclosure. Those are the two fundamentals, in my respectful submission, which guide the underlying issues which arise in this matter. This matter is not about contribution limit, except on that 7.5% issue, or expenditure limit, or expenditure timeline, which is when can the parties spend before election, after election. Those are all aspects which are litigated not just in our jurisdiction but across the world. This is about something which pervades all those aspects, which is disclosure. Every aspect it pervades, which is disclosure, and disclosure not just to authorities. There are two kinds of disclosures. One is I should only disclose to the Election Commission. That may not be sufficient. This is about disclosure to the authorities and to the public at large. And that is where the rights under 19(1)(a), 326 come into play. Because insofar as why this is relevant from a perspective of democracy, the principle of one man, one vote, it's not just about that I cast my vote. What is the substantive value of that vote? Because it basically entitles me to claim equal representation to my representative, equal influence over the democratic process, and to show that my views have equal worth in the system. This scheme possibly changes that by shifting the center of gravity from the elected public to somewhere else of the political discourse and influence without the public even getting to know about it. With that, I will enter the first submission, which is the architecture. What does this scheme do? This scheme effectively is an alternative white money channel which the government has created. There was already a disclosure-based channel, the normal banking channel, the RTGS, the bank draft, the check, which was available. This is a new white money channel. What they have added is anonymity to it. By definition, therefore, it cannot be including money which would otherwise be black money. It can only deal with money which will anyways be white money, which a person can disclose as white money. The function of whether a money is disclosed to a banking channel and therefore declared as white is not a function of what it will be eventually used for, whether to donate to a political party or something else. It's primarily a function, I don't say exclusively, primarily a function of two things. First, whether the money is legally obtained. If it's illegal money, I can't disclose it to a banking system normally, unless I'm trying to launder the money. And second, if I'm trying to suppress my income is X and I'm trying to show Y to save tax. Plus, this will not bring in any of that money which is anywhere in the black space, in the cash economy. So what does this do? By definition, what this will do is the existing white money which is in the system, which was being donated to political parties through the non-anonymous fully declared route, it will shift that to anonymous electoral bonds. That's more or less the scheme of the architecture of the electoral bond scheme itself. And my lords, that is borne out by data as well. Now, your lordships will just, I'll try to bring my lords to the data straight away. First, my lords, in terms of what is the cash usage in the economy. Because of course, cash usage, there can't be a perfect number that this is the cash usage in electoral system. We always have to go by surrogates, some surrogate. So my lords, in that context, we'll look at, I'll compare the 2014 Election Commission recoveries of cash during election, the 2014 general election, and 2019. The amounts of cash recovered in 2014 have gone up by 3 times in 2019, which by itself is indicative. If the commission is catching more money, that means there's more money in circulation. A large chunk of it will be belonging to political parties. So your lordships will first have volume 4, my lords will have page 1825. This is, my lords, the 2019. I'm only relying on Election Commission data for my submissions, no outside data, my lords. Page 1825. This is all the recoveries they made in the 2019 election. You will have, your lordships will have page 1826. At the bottom, grand total.
Second column is liquor.
At the bottom allows a grand total on page 1826. Well, it says cash 844. Your lordships have that?
Largest in Andhra and Tamil Nadu.
To the extent that cash is used in the elections, maybe this will show that.
So, my lords,
That's a limited extent.
I agree. I'm grateful to my lords.
We ought not burn that.
So, my lords, my point is that cash can only increase. Cash cannot be controlled by definition by this scheme. Plus, this scheme, let's assume, my lords, that cash was tomorrow even banned, for instance, by political party. Cash can still be used by political party. That's a reality, unless the cash economy itself ceases to exist. So this scheme, because I'm trying to meet the argument which is in support of the scheme by the union right since the beginning, including in their affidavits, that we are trying to transfer what is there in the cash economy into this. My submission is that is just not possible given the nature of this scheme. In fact, it's not possible unless, even if you bar prohibition, even if you prohibit it, you possibly can't do it unless the cash economy itself ceases to operate, independent of political parties. So, that is really a red herring argument, is my submission for your lordship's consideration.
The argument of the other side on that is they are trying to experiment. If it is possible, they can do it. If they can wean away from the cash.
So,
That may not really cut. We can't say that the attempt should not be made or experimentation should not be made.
but what if it were to primarily impact the other side which was already being disclosed? So what's happening now is you have 2 channels, anonymous cash channel and anonymous banking channel. So what the white and the black channel are anonymous now. My submission for lordship consideration is this. There was earlier a black channel, the cash channel which was there, which needn't be disclosed, etc. Now you have created an anonymous white channel. So both are anonymous. And this is at the cost of only one thing, which is disclosed white channel. Because I'll try to make that good. I'll try to, even through data, I'll try to make that good, because we have the benefit of 5 years of operation of this scheme. Because that's the benefit we have. So what's the impact of it? Parties which were getting 70 to 75% of their political disclosed contributions from check, bank, RTGS, that's the disclosed white channels, are now getting 20%, 15%. The electoral anonymous scheme has taken over at the cost of white channels. So my submission for your lordship consideration is this. It's not to attack the black money. It's actually to attack the white disclosed channel. And that's the actual impact as well of the scheme. And Mulaz, I'll just place the data and then Mulaz, I'll go to my next point. What we have done, we did an exercise. What we have done, Mulaz, at 29 seats, every party gives a contribution report above 20,000. Above 20,000, they're required to. Mulaz, we collated the last 10 years from 2013 onwards, all the reports. And Mulaz, your lordships will have page 5542, just for a moment, just at volume 4.
542.
5542. 5,542. Volume 4. Plus at 5543, this is formulas two parties, the two national parties I have collated. Well, the data is for all of them, but when I show the bar graph, that is for two parties, and I'll tell you lordships what we have done. 5543, your lordships will have. Lords have that.
These are list of donors who came.
That's right. So from each of the list, we have taken all the list of donors, and it says against that, for instance, it says check number, DD, etc. Correct? My lords will have the first cash entry in this one is at 5553.
That's less than 2,000.
No, it's more than 20,000. Plus more than 20,000, you have to disclose whether cash or check. Either way, you have to disclose. That's the statutory requirement. 5553. Look at 153, serial number 153 in that chart. Some Mr. VV, 1 lakh cash. My lords have that? Page 5553.
Yes.
VV. So, Mulaz, what I have done, Mulaz, each entry we have added up for two largest political parties for 2 years to get the numbers, because there was no other way to do it. This is not information available in the public domain. This was the only way to do it. So we have added up each of the entries to determine what is the check amount which they were getting as a percentage of their funding in 2013-14 and what they're getting post-electoral bonds. And Mulaz, the net result of that, Mulaz, I've prepared a chart for your lordship's consideration. The learned courtmaster will kindly screen share that document which has been emailed. Yes, give a copy to the learned solicitor.
Airdrop.
Awesome. Plus, your lordships will have it on your screens now. Not just the if the learned courtmaster can bring it down a little, just. Yes. Correct. Yes. So, Manoj, my respectful submission is now the entire political funding substantially is anonymous. Because black channel continues. Mulaz, at the cost, if the objective is to have some kind of disclosure, at the cost of disclosed white money, if you are increasing non-disclosed white money, Mulaz, that's what the real, your lordships will have this chart, page 1. If the courtmaster can just bring it down a little.
There's a little flaw because of the bearer bonds as such are bearer bonds, that's creating a problem. That's all. We have understood that argument.
And Mulaz, I'm making the argument solely to meet the union's justification of the scheme, which is that it's meant to bring in black money into the white system. My respectful submission to meet that is, it actually does the opposite. It takes away the non-anonymous white money and puts it in the anonymous kitty. That's my submission.
That we already appreciate.
That's right. So Mulaz, I am saying, therefore, to that extent, A, the justification is not valid, and B, for that reason, it's arbitrary as well. It doesn't meet even the stated justification.
Already argued by Mr. Sibal.
Because the determining principle, because one of the tests of arbitrariness your lordships have stated is, it is absent a determining principle. Because here the stated determining principle is contrary to what the scheme actually does and intends to do.
What it basically, according to you, does is that it brings into the fold. Earlier, what you had non-anonymized white money.
That's right.
Now that is replaced increasingly by anonymized white money.
And that's the real victim or target of this scheme, not the black money. That's my respectful submission. Because black money will continue irrespective. That funding will keep on continuing. So now the two channels, both are anonymized, white and black. That's my respectful submission. That's the scheme. That's the real picture which this scheme does to our political financing, Mulaz. That's what it does.
All right.
Yes.
Anything else now, Mr. Farad?
Plus, just two short submissions, I will not labor them. Plus, the second point is your lordships will consider that under Article 326, Mulaz, there is guaranteed adult franchise. There's some debate on whether it's a right to vote or not, because the right to vote actually specifically vis-a-vis an individual voter flows from Section 62 of the Representations of People Act. But Mulaz, it is definitely, it defines what an electorate is. 326 at a minimum defines what an electorate is. My lords, will just have 326 for a moment. The elections to the House of the People and to the Legislative Assembly of every state shall be on the basis of adult suffrage, that is to say, every person who is a citizen of India and who is not less than 18 years of age on such date as may be fixed in that behalf by or under any law made by appropriate legislature and is not otherwise disqualified under this constitution or any law made by appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice, shall be entitled to be registered as a voter. So this is a creation of an electoral list. You are entitled to be registered as a voter. So this gives you what is the electorate. It may not give you a final right to vote because that will still be regulated by the statute in terms permitted by 326 itself. So I don't want to get into that debate. Recently, there are differing views of this court itself. Because recently in the Election Commission appointment court, a 5-judge bench of this court has taken the view that although it is a statutory right, they're not giving a definitive finding because the earlier 5-judge bench had said that it is only a statutory right. So I don't want to get into that debate. Even assuming this is not a right, it is at least defines the electorate. And this, when read with 19(1)(a), it envisages, in my respectful submission, an informed electorate. So when your lordships will nest the right to information, my submission before your lordships is nested not just in 19(1)(a), but also nested in the informed electorate under 326. And what's final submission, the third and final submission. Plus, it impacts two kinds of democracy, this scheme. One is popular democracy and the other is shareholder democracy. The only people who are part of we, the people in the company, is the shareholders. They also vote. That is the natural shareholders. They are the only ones who are excluded from knowledge of where the money is going.
Already argued by Mr. Sibal.
Just on one aspect, on that, I quite see that. Another shareholder, a share is a property of a shareholder. My property's usufruct is being used to fund a certain purpose. Well, this is my written submission. I won't take your lordships to it. But political views have also been recognized by this honorable court as part of right to conscience. I don't even know who my money is being used to fund for. A person with A conscience may not like a right-wing party. A person with B conscience may not like a left-wing party. It may infringe on his conscience to support his property to fund that party. So at least I should have a right to exit. I can't certainly manage the company being a single shareholder, but I should have a right to informed exit. I'm even denied that by blackholing the information from me. So Manoj, in that sense, it actually violates the Article 25 right of a shareholder. Manoj, I'm grateful for that.
Thank you, Mr. Prashant. Yes. Yes, Mr. Prashant.
My Lord, I appear in item 501.3, which is Pandan Biswal versus Union of India. Lordship, the petitioner is a practicing advocate of my Lord's court and a specialist in financial regulation. And so it's in the perspective of placing this law into the context of financial regulation that I stand before my Lord. My Lord, just before I begin with that, I just want to round off the argument that was being made by my learned friend, Mr. Farasat, for which, my Lord, I refer to clause 11 of the electoral bond scheme, which is the payment options. And I'll read it out, my Lord, need not bother. It says, all payment for the issuance of bonds shall be accepted in Indian rupees through demand draft or check or through electronic clearing system or direct debit in the banker in the buyer's account. Lordship, so cash is noticeably absent from the forms of consideration which are permitted for purchasing an electoral bond. And therefore, the question of any black money coming into the system has been cut out at the inception itself, at the stage of purchase itself, is excluded. Lordship, and I contrast this with the bearer bond scheme, which was under consideration of my lords in R.K. Garg's case, where, Lordship, the specific and stated objective of the government was to bring black money into the white system, and therefore purchase of those bearer bonds through cash was permitted, and that scheme was eventually upheld on the basis that all other, it's just providing another instrument, because all other laws, etc., will continue to apply, and wherever there is a financial irregularity found in terms of income tax, etc., the person will be liable. But just the cash which existed in the economy, which existed outside the white economy, comes into the white economy, which is the one thing which is excluded in this case. Lordship, so the one ground on which a similar scheme of bearer bonds, not in the context of elections, was upheld by my lords in R.K. Garg, is the one ground which is not available here. Lordship, now my primary argument is that this the electoral bond scheme is manifestly arbitrary. And for that, Lordship, I will just read out the relevant few lines of my Lord's judgment in which the concept of manifest arbitrariness is defined. And Lordship, just by way of an aside, I wish to point out that it is commonly believed that the doctrine of manifest arbitrariness and the striking down of legislation on the grounds of manifest arbitrariness came into our system and became the law through Justice Nariman's opinion in Shaira Banu. Lordship, I feel that that is actually not correct, because Justice Nariman was in a minority in terms of the doctrine when he expounded the doctrine. Justice K.R.'s opinion said that personal law is not statutory, and therefore the question of striking down a statute did not arise under Article 14. Justice Kurian Joseph, while he is with Justice Nariman on the operative directive, disagrees with him on the fact that it is statutory. And so, in that sense, his one line saying that I agree with my brother's opinion on the doctrine of manifest arbitrariness is completely obiter for Justice Kurian, because he is saying that this is not statutory and therefore not subject to Part 3. So, in that sense, that opinion is an opinion of 2 judges, but it was in Puttaswamy 5 judges, where Justice Sikri, speaking for the majority, applied and adopted that doctrine of Justice Nariman, that I feel that it for the first time became law. But now that it is, Lordship, I'm just reading from para 95 of the opinion of Justice Nariman as adopted by Justice Sikri.
So how do you formulate that it is? Just give us how, according to you, it is manifestly arbitrary.
Lordship, that
you have the doctrine of manifest arbitrariness you have referred to in your written submission.
Lordship, please.
That we look at. If you can formulate how it is manifestly arbitrary.
Lordship, please. So I'm just, what are the elements of manifest arbitrariness is important for that. And a constitutional infirmity is found in Article 14 itself whenever legislation is manifestly arbitrary, that is, when it is not fair, not reasonable, discriminatory, not transparent.
So in our case, how is it manifestly arbitrary?
Lordship, not transparent, so ipso facto. Not transparent, capricious, biased, with favoritism or nepotism, and not in pursuit of promotion of healthy competition and equitable treatment. Positively speaking, it should conform to norms which are rational, informed with reason, and guided by public interest.
So according to absence of transparency.
Absence of transparency and Lordship, public interest. And for that, Lordship, I am just juxtaposing the legislative policy behind these amendments and the electoral bond scheme with the legislative policy that exists in the context of other financial regulation. Lordship, in the electoral bond scheme, in rule number 3 or clause number 3, which is eligibility to purchase and encashment of electoral bonds, I'm reading it out. The bond under the scheme may be purchased by a person who is a citizen of India or incorporated or established in India. So, Lordship, the only test for a company is that it should be incorporated or established in India. In all other financial regulations, Lordship, I will point out that there is a concept of beneficial ownership where if beyond a certain percentage, there is foreign ownership in that entity, it is treated like a foreign source. But here, to purchase an electoral bond, as long as the company is incorporated in India, it is an eligible purchaser. And Lordship, what this results in is the absurdity that while we do not permit investment by an entity which has 51% foreign shareholding, we don't permit that entity to invest in a company which, say, deals in the media, because we don't want foreign control of our media. But we have no problem in allowing such a company to purchase bonds and transfer to political party, and therefore, in that sense, invest in a entity that runs the country. So, that's the absurdity that I wish to point out, Lordship, that in all financial regulation, the idea of control and beneficial ownership of foreign corporations and a different standard being applied to them is the norm. And it was the norm here as well, because under FCRA, before the amendment, an entity which had more than 51% foreign shareholding was treated like a foreign source. But this amendment now does away with that and treats all entities, as long as they are regulated in India, at par. And I wish to point out, Lordship, some of the differences that exist between this scheme and the scheme of any other method of funding coming into India. Lordship, foreign investment in India is governed by the Foreign Investment Management Non-Debt Instruments Regulations 2019. Lordship, which are at page 9047.
Your Lordship's made it clear in the morning. This issue is detect.
This is not FCRA. I think it's under the impression that I'm dealing with FCRA. I'm talking about foreign exchange management. So I'm just placing this electoral bond scheme in the context of foreign.
They are twin arguments.
That's not a twin. That's FCRA is a separate argument there, which is I'm talking about foreign exchange management, Lordship. So because in this context, when in Rule 3 it says that any entity incorporated in India may purchase electoral bonds. So by definition, a company with foreign investment is being allowed to purchase electoral bonds. And so, Lordship, I just wish to point out that
already been argued that any entity in India which is merely registered in India, even if it doesn't carry any activities here, doesn't earn any profit, still a company is situated in abroad can use this company as a shell company and permit it to be transferred.
I'm going to pitch it a step higher, Lordship. I will point out that the government and the legislative policy does not permit a company from incorporated in certain jurisdictions to even enter into procurement contracts with the government. But for purposes of funding political parties and thereby having a say in the electoral politics of this country, there is no problem by virtue of this amendment. So just the comparison, Lordship, points out the legislative absurdity of having a clause here which places all Indian corporate entities on a similar footing. Lordship, I was looking at I was pointing my lords out to the regulations at page 9047 of volume 4. Lordship, and I am reading Rule 23. Indian entity which has received indirect foreign investment shall comply with the entry route, sectoral caps, pricing guidelines, and other attendant conditions as applicable to foreign investment. which means that a company which has downstream foreign investment, which has foreign investment in terms of its downstream investments, it is treated like still a company which is a foreign investor for purposes of foreign exchange management. So, Lordship, and hence the absurdity that there are certain sectors, for instance, which are prohibited for foreign investment, like atomic energy or defense or space. There are certain sectors which are restricted to foreign investment, like, for instance, media, where more than 49% ownership is not permitted. So this company can't invest in all of those sectors and in companies engaged in those businesses, but is allowed to invest in, or rather allowed to transfer its funds to a political party and therefore become a stakeholder and participant in the electoral democracy of this country. Lordship, I won't take my lords to those pages, but I'll just point out, my lords, to the master directions which are issued under this scheme, at page 8850. Lordships will note at page 8877, first at page 8875, downstream investment. And the way it's worded is very relevant. The underlying principle of downstream investment guidelines is that what cannot be done directly cannot be done indirectly. So therefore, Lordship, foreign entities are not being permitted to purchase electoral bonds. But an Indian entity with foreign investment, even if it's 100%, is permitted to purchase electoral bonds, which is prohibited in the context of business, but is permitted in the context of political parties. Accordingly, downstream investments, which are treated as indirect foreign investments, are subject to the entry routes, sectoral caps, or investment limits, as the case may be, and pricing guidelines and attendant conditionalities for such investment as laid down in the non-debt instrument rules, which I read out. And ownership of an Indian company is the beneficial ownership of more than 50% of the equity instruments of such a company under this FDI policy. Lordship may now take page 8900 of volume 4.
What is the submission now?
Lordship, this is press note 3 of 2020, by which it has been stipulated that any country which shares a land border with India, investment from such a country is treated on a different footing from investment from any other country. And whereas investments, say, in the manufacturing sector may be a 100% automatic, but if it is from a country that shares a land border with India, that is solely under the approval route, which means that it will not be automatic. It will require an application to be made for approval to the government of India. Therefore, Lordship, what submission that I'm trying to make is that an investment from China into a manufacturing entity is not treated as par as investment from anywhere else. But if the same country then permits purchases electoral bonds, then that is permissible. Again, so this land border sharing distinction that exists for business doesn't exist for...
Yeah, because that is taking into consideration the interest of security of the state.
Lordship, exactly. So therefore, if security of the state is impacted, if a company merely invests in the manufacturing sector in India, is it not impacted if Chinese investment is coming into a political party? Lordship, so much is being made today.
It is coming. It has stopped now because of this.
Lordship, so we are currently having this issue which is in the press of a news organization having received some fund from China. So Lordship, so by this standard, a country like China cannot invest into businesses in India except through a separate approval route where it is monitored and scrutinized. But a Chinese company can fund a political party and theoretically funnel millions of dollars into politics in India on a, presumably, like my friends have already argued, a principle of quid pro quo. So Lordship, in fact, that difference in legislative policy for funds coming into India in any other context versus in the context of political parties manifestly arbitrary is my submission. Lordship, one or two more instruments I'll just point out to my lords. My lord may see page 8827
a matter of policy, really. Whether you know, you are saying that well, a company in China, because China shares the land border, they cannot bid for a contract. But your case is here that well, they may have invested in electoral bonds.
So therefore, we feel that there is a security threat if they bid for a contract in India, but we feel no security threat.
They are in the realm of policy, you know. That's
But in fact, that is why policy is subject to the doctrine of manifest arbitrariness if it is so absurd, where it is contrary to public interest and where it is non-transparent.
Thank you. We'll now tomorrow, at the most, Mr. Hansaria, 15 minutes for you and 15 minutes for Mr. Hegde now.
It's for me. It's just 10 minutes. I represent a regional party. We had made an application, written submissions for that. I won't take more than 10 minutes.
We'll have a look at the written submissions of Mr. Hansaria, Mr. Hegde. And
To be on realistic side, not 15 minutes. I was requesting your lordship an hour. I'll try to have it in 45 minutes. I have to take your lordship the journey from 1958, my lord, how it developed, not since 2013. There is a long journey, my lord. The parliament has accepted the recommendations made by Justice Chagla, and I'll show to your lordship, lord. I'll try to be as brief as possible.
Who are you appearing for, Mr.
Sir, I am for an entrepreneur, my lord. We have, I filed my written submissions, which are before your lordship.
I also make submissions.
I have, no.
And based on that, we'll decide in the morning how much time.
As brief as possible.
Shall I also make a very short submission?
I will try to be as brief as.
Shall I make a very short submission, my lord, before your lordship parts with, my lord? But I just wanted, I was listening to the entire deliberations, but I wanted to make a very short supplementary submission. But we only with respect to the question of political liberties.
Submissions, all three of you, and then we can see how much.
Please, your lordship.
So we will begin with the clean slate.
Your lordship will see that, and then whatever your lordship says, we'll go by that.
Shall I make one request, my lord? Shall I make one request before your lordship leaves, my lord? But I will just make a very short submission supplementing, my lord, and emphasizing on a point which has not been addressed at all. That is to say, on political equality and the basic feature in the Indian constitutional context. You know, distinguishing.
Filed your submissions, Mr. Raj, no?
Yes, I wanted to make a submission, but distinguishing.
Have you filed your submissions? Have you filed your written submissions?
I can do it today if your lordship permit, because I was prevented.
Now
with
it's
the
too
hearing.
late.
I can do it today if your lordship.
We can't take the attorney and the solicitor by surprise.
I will just rely on my immediate.